Can you kind of paint a picture for people about what they can actually expect when they enter a court building?
So I have been doing this for about 13 years and I've never gone to a hearing and anybody has stood up and said, I object. So that just doesn't happen here. And again, the court very much wants to try and help you resolve the dispute at that stage. They will look to narrow the issues now that we've got the information we need and see how we can try and move everything forward.
You made the point that just because you've issued your application, you get to the first hearing does not mean that you have to go all the way to the end of the proceedings and go all the way to a final hearing. Probably of a typical lawyer's caseload, you might have 10% of those cases in court. And of those 10% of cases that are in court, you might have 5% that go to a final hearing.
There is such an emphasis at the moment on non-court dispute resolution and trying to resolve disputes, whether they are financial or children disputes, away from the court process.
Welcome to Life, Love and the Law, a podcast by Stowe Family Law. My name is Liza Gatchell and today I am joined by Shivi Rajput, partner at Stowe Family Law in our London office. So welcome to the podcast, Shivi.
Thank you.
Today we're going to be talking about what to expect at a family court. But before we do that, would you like to introduce yourself to the listeners?
Hi, I'm Shivi Rajput. I am a family law partner at Stowe in London. I have been a family law specialist for the last 13 years. And I help clients with a broad range of family law issues. So I deal with divorce, finances on divorce, complex child arrangements, pre- and post-nuptial agreements, and some domestic abuse work.
Brilliant. So topic today, what to expect at a family court. When we say family court, we don't mean just one type of court, one building where it all looks the same. So can you start by just explaining exactly what the family court is?
Absolutely. So the family court is a court that is set up to deal with family law disputes. So they will deal with what's going to happen with finances on divorce. They will deal with child arrangements and who the children are going to spend time with, where they're going to live. They will deal with applications for injunctions, so protective injunctions like non-molestation orders and occupation orders against spouses, against ex-partners, etc. So it's a court that deals with those types of family law issues. There is a single family court, but they sit at different centres all across the country. So you have the family court sitting at Staines or family court sitting in Slough, and they sort of sit all around the country.
There are different types of court, as in that sometimes you'll issue an application and it will go to the magistrates' court.
Yes.
And you will have lay magistrates, and then you might issue an application, it might go to the county court and you'll have a judge. Can you just explain the difference between the different levels of court?
Yes, absolutely. So with the magistrates' courts, magistrates are lay people, so they don't have legal background or legal training. They are sort of upstanding members of the community and society that have been given that position. And magistrates, they usually hear simple child arrangements cases. So cases where there aren't complex safeguarding issues or any complicated issues in relation to child arrangements. And magistrates are supported by legal advisors. So the legal advisor is there to listen to everything that's happening within that hearing and will give the magistrate some guidance in terms of the law. But the magistrates will make decisions on those sort of simple cases. You have more complicated cases, so cases, for example, where there have been allegations of severe abuse that affect the children, allegations of parental alienation, or sort of more complicated relocation type of cases. And they might be allocated to a district judge or a circuit judge or potentially even a high court judge, depending on severity of the issues involved and the level of the judge that this particular case warrants. And it is really, you make your application and it will be the court that determine where the case is going to be heard and whether it should be allocated to magistrates or a different type of judge.
People tend to panic a lot about going to courts. We get a lot of American TV over here, so we have a picture of what court's going to be like. Can you kind of paint a picture for people about what they can actually expect when they enter a court building?
So I have been doing this for about 13 years and I've never gone to a hearing and anybody has stood up and said, I object. So that just doesn't happen here. Our proceedings, family law proceedings, are generally private. So what that means is that there's no jury present. There's typically no reporters. There's typically no press. These are private proceedings. So although, if you're in family court, you can bring family and friends for moral support within the court building, they wouldn't be allowed inside the courtroom. They wouldn't be allowed to hear what the judge is saying. These are private proceedings. And they're just nowhere near as glamorous as what we see in American TV. The buildings are fairly run down, if I'm honest with you. There is sometimes nowhere to sit and have private discussions with your legal team. Sometimes you're having those discussions in a corridor in whispers because there is nowhere for you to go and sit. So absolutely nowhere near as glamorous, but also nowhere near as scary. They're not dramatic. They're not theatrical. It is typically just a room, far less scary, a room where a judge is sitting there with you sitting next to your legal representative and the judge asking some questions to see how they can get to the bottom of helping you with your dispute.
And there will be different types of hearing.
Yes.
And we probably need to talk about kind of children's proceedings and financial proceedings separately because they're very different. So if we start with children's proceedings first.
Yeah.
So let's say I've issued an application for a child arrangements order.
Yes.
What type of hearings can I expect? How many are there likely to be?
So how many will always depend on the circumstances of your individual case, but very typically you might have about 3 hearings. So the first hearing is your first hearing dispute resolution appointment. And typically that's kind of a case where the judge will consider the papers. They will consider any safeguarding reports that CAFCAS might have done. So CAFCAS will usually have had a brief conversation with the parties beforehand, and they will give the court a summary of any police involvement in the family's case, any local authority involvement, a summary of what both parties want. And the court really at that hearing is just looking at what are the issues here? What do we need to help move this forward? Can we come to an agreement? If we can, fantastic, everything stops. If we can't, we progress to a second hearing. And in advance of that second hearing, the court will have told you at the first hearing what needs to happen. So that usually is things like the court might require both parties to do a witness statement to give more information about allegations they might want to raise. The court might order a welfare report to be produced either by CAFCAS or by the local authority. They might want some other form of expert evidence. So we might need, if there is a child with, for example, severe disabilities, we might need a medical expert to come in and provide some information to the court. And we get to the next hearing, which is typically a dispute resolution appointment hearing. And again, the court very much wants to try and help you resolve the dispute at that stage. They will look to narrow the issues now that we've got the information we need and see how we can try and move everything forward. And if that's not possible, then the court will typically list it for a final hearing. And at a final hearing, both parents will give evidence. So they will be asked questions by their barrister and the other party's barrister and potentially by the judge about what their positions are. And the judge will then make a decision which is binding on both parties.
Perfect. So that's children's proceedings. How do financial proceedings then look different to that?
So again, the number of hearings in your case will very much depend on your individual circumstances. But again, there are typically 3 hearings that you would go to in financial proceedings, and they follow roughly the same sort of approach. So your first hearing is really an administrative hearing. You're going to court and the court is making a timetable of what else they might need, what further information might be required in order to progress to the second hearing, which is your financial dispute resolution hearing. And that's really the negotiation hearing. That is a hearing where both parties provide the court with their respective positions. So, for example, you might say on behalf of your client, my client thinks the family home should be sold. He thinks that there should be no need for any spousal maintenance to be paid. He thinks that pensions should be divided in this way. The judge will hear from both parties. If you're represented, they'll hear from both parties' representatives about what their respective positions are. And the judge at that hearing will then give an indication. So the indication really is the judge saying, if this were a final hearing today, I would make the following orders, and this is why. The indication is not binding on either party, and it's really just there to give the parties a sense of, if this one judge thinks that this is the way to settle this case, the chances are that another judge might have a very similar, if not the same approach. And therefore, can we try and negotiate a settlement around this indication so that we avoid the need to go to a final hearing? FDR hearings, they usually take all day, and it is very much there for both parties to negotiate and try and come to a settlement. But again, if you can't, the court will list it for a final hearing, where again, similar to the children, the judge will hear both parties' positions and will then make a binding order on them.
Yeah, it was really interesting. You made the point that just because you've issued your application, you get to the first hearing, does not mean that you have to go all the way to the end of the proceedings and go all the way to a final hearing. actually the court really does promote you trying to settle your case along the way. I think if people go to see a family lawyer, we often talk about final hearings because we talk about, well, this is what a judge is likely to do in these circumstances. And that can in itself panic people because they kind of think, oh my goodness, like this decision is going to be taken out of my hands and I'm on this conveyor belt now and I can't get off it. My experience of the number of cases that get to final hearing is that probably of a typical lawyer's caseload, you might have 10% of those cases in court. And of those 10% of cases that are in court, you might have 5% that go to a final hearing. Would you say that's about right?
I think so. I think there is such a push now for parties at all stages of the dispute to consider what we call non-court dispute resolution and to try and resolve the dispute as far away from the courtroom as possible. It's not a pretty process to be involved in. The building's not very nice. The whole process can feel very draining, exhausting, and parties are very much encouraged to try and come to a settlement outside of the court process. And it's certainly something that we do with all of our clients. We'll think very carefully about the need to issue proceedings. Sometimes it's inevitable because sometimes you come across somebody who is refusing to provide financial disclosure and therefore you can't work out what a fair settlement might be because you don't know what their bank accounts say and they're refusing to provide that information. So sometimes you have to issue in order to get the information you need to work out what a reasonable settlement is. But all the way through the process, we are always looking at trying to settle proceedings, and the court is as well, trying to get the parties to narrow their issues and narrow the dispute and trying to look at how we can come to hopefully an agreed settlement. So absolutely, I think final hearings are quite rare, but they are there as a backup in case you are in a situation where you just cannot come to an agreement with your ex.
Yeah. And you were talking about sort of FDRs and final hearings that you might be at court all day, that these can be quite long days. Some really practical tips, if you like what should I wear to court? What should I take with me?
Yeah.
Who should I bring?
So in terms of what you should wear, I always say to the clients, be comfortable. Come dressed smart because I think it's an important process, an important time in your life and it's good to look respectable and presentable. But you don't need to come in a suit. Come dressed comfortably for the day. As you say, these days can go on for a really long time. There's a lot of back and forth in between meeting rooms and the courtroom. If you're on medication, make sure you've got your medication there. If you need to pack some paracetamol or ibuprofen, make sure you've got that stuff with you there with a bottle of water. Things just to keep you sustained throughout the day. So, a banana, a bottle of water, those kinds of things. As I said earlier, you can bring people for moral support. So you can bring family or friends. They are not allowed in the courtroom itself. So they will only be able to be with you sort of in your waiting areas, etc. But often what we find is that if you're there with your legal representative, so usually you're there with your solicitor and your barrister, that's probably enough of a support network for you. And again, as I said, a lot of the time when you're in these court buildings, there isn't ample space for you to have a meeting room and you might be squished in a corridor somewhere. So kind of limiting the amount of people can be quite helpful as well.
I think my biggest tip is snacks.
Yes.
Pack a lot of snacks. It's a really, really long day.
Absolutely.
And you need to make sure that you've got the energy to get through it. And you were talking about the court buildings, but the cafes often are either closed or it's just a vending machine.
Yes.
Where you don't get a particularly great choice of things and you may not get a lot of breaks to be able to go out and find somewhere local. Bring a lunch and bring some snacks.
Absolutely.
I was just thinking about something else that clients certainly say to me that they really worry about with going to court. And that's talking to the judge and standing up and being put in the witness box. Like, how likely is it that they're going to need to speak to the judge?
What you've just referred to about standing up and being in the witness box, that will only happen if you get to the final hearing stage. And as we've discussed, that they are very rare in these types of proceedings. Often we're able to settle before you get to that stage. If you are in the final hearing, you are going to need to give oral evidence in your case. So you will go up in a witness box and you will be asked some questions by your barrister to start with, by the other side's barrister, and potentially by the judge. That's really the only time that you would be asked those types of questions. In all other hearings, if you are represented, typically you won't be asked anything. Your barrister will be presenting your case for you. The judge will ask your barrister many questions, and sometimes they ask the clients directly, but they're not scary questions or anything you need to be worried about. They wouldn't ask you anything legal. You don't need to worry about any of that. They might ask you, for example, to clarify a date of birth or an address. So really just factual information. As long as you are represented, your barrister will do that work for you. If you're going to court as a litigant in person, then yes, the judge will be speaking to you and the onus will be on you to present your case and answer their questions.
So you were just talking about litigants in person. So that's somebody that's representing themselves through the proceedings, doesn't have a solicitor representing them. What are the implications for somebody if they are issuing the application without any legal assistance? What do they need to bear in mind?
So litigants in person are still going to have to comply with court orders and practice directions. So we have a practice direction in the family procedure rules, which sets out all of the rules and guidance on what advocates and solicitors and litigants in person need to comply with when they are issuing an application and dealing with the entire court process. For example, there are rules on if you're going to a financial hearing, the parties need to have provided the court with a case summary or an ES1 and an asset schedule or an ES2. And these are specific forms that need to be completed in a particular way. And if you're a litigant in person, you are still expected to comply with those rules, still expected to furnish the court with a court bundle. So a court bundle is essentially the file of papers that the judge has with all of the information that the judge requires in order to make a decision about this case. So even if you don't have a solicitor or a barrister, you do have to comply with the orders. You do have to understand what the practice directions say and comply with them.
So ignorance isn't a defence. I can't just turn up to the court hearing and go, well, I didn't know.
Judges are usually more lenient with litigants in person than they are with legally trained people for obvious reasons, but there are still rules that need to be complied with. Judges have a number of hearings in their diaries in a particular day, so they need to be helped in terms of this process. And a lot of the time, that's what your solicitor is there for. They're pulling everything together to help the judge, to help the barrister present the case effectively. But if you don't have access to a solicitor, you do have to take on that work yourself.
You were talking about court buildings and saying that sometimes there aren't enough waiting rooms and sometimes we're having to have whispered conversations in the hallways. If I'm the victim of a domestic abuse and I have made an application to court, whether it's children, finances, or for an injunction, and I am frightened of my ex-partner, what can be put in place to protect me?
So it's really important if you are the victim of domestic abuse that you do reach out to the court in advance of any hearing and let them know that this is the case. They can put several safeguarding measures in place. They can do things such as having designated separate waiting rooms. So I talked before about sometimes there's not enough space. There is usually a waiting room and they can block it off and make sure that you are the only person that's allowed in there. They can organise things so that there are separate times for your arrival, so that you arrive before the other party does or that you leave after they do. Security can be on hand to assist with that. When you're in the courtroom yourself, screens can be put up between you and the perpetrator so that you don't have to see them. And if it just feels too much to be in the same court building, you can also apply to the court to ask if you can attend the court remotely. So the courts can have hybrid hearings where one party attends in person with their legal representative and the other party attends via video link. And that can be, again, another way of ensuring that there is safety and that your safety is given paramount consideration. So flag it as the earliest opportunity, reach out to the usher when you get to court to make sure that they are helping to implement any of those safeguarding measures.
And you just spoke about hybrid hearings in the context of domestic abuse, but what if I was living in Japan?
Yes.
And I didn't want to fly over to the UK to attend the hearing, or even, to be honest, if I'm living in Portsmouth and the hearing's taking place in Liverpool, the commute to that would take a significant amount of time. Is it possible to attend a hybrid hearing in those circumstances as well?
Absolutely, if you have permission of the court. So hybrid hearings and remote hearings are becoming more and more popular. I don't know about you, but prior to COVID, I'd never been to a remote or hybrid hearing. You had to go in person all the time.
Yeah.
One of the huge things that COVID brought in was the ability for everybody to do work remotely. And that applies to the court system as well. So lots of the time nowadays for your initial hearing, whether that's your children or your finances, they often take place remotely. They are no less serious in nature. You are not allowed to record the proceedings. You have to be in a room by yourself. Nobody else can be around or with you. And the judge is there and reads out these warnings. It has the same effect of being in the court building, but it's done from the comfort of your home or from your solicitor's office or your barrister's chambers. And a hybrid hearing, as I mentioned earlier, where, half of the team perhaps are in person in the courtroom and the other half are attending remotely. And that can happen if they are abroad. We had a case recently where somebody was stuck in Dubai because, of all the air issues and planes being cancelled, and they couldn't get back for a hearing, and we were able to have them join remotely via a video link. So All of these things are possible. You need to reach out to the court in advance and you need to get the judge's permission. So you can't just assume that just because those things have happened, you're allowed to do it hybrid or remote. You do have to have the judge's permission.
One of the questions I get asked is in relation to children. So talking about children's proceedings, will the judge speak to my child within the proceedings? Because Johnny is absolutely adamant that he doesn't want to go to contact, and I want to make sure that his voice is heard within those proceedings. What advice would you give there?
So it very much depends on how old your child is and their own levels of capacity. So you can have a child who perhaps is 12 years old, but isn't perhaps as developed as another child, and perhaps their wishes and feelings are not going to be given as much weight. It is very, very rare for children to speak directly to the judge. What children will often do is speak to a CAFCAS officer. So they are specially trained social workers who deal with children. And they may come and observe time spent with the child and the other parent. They will speak to the child individually, but in very child-focused terms. So they might, for example, depending on the age of the child, ask them to draw a picture of what a happy home looks like and try and gauge their wishes and feelings in a child-appropriate and age-appropriate manner in those terms. And the CAFCAS officer then reports that back to the judge and to the parents in a report. It may be circumstances where a child is absolutely adamant that he doesn't want to spend time with one of the other parents, and the other parent is alleging that this isn't a true wish or feeling, but they have been manipulated or coerced into having that view. And in those sort of circumstances, a judge might determine that it is appropriate for a guardian to be instructed. So for the child to have their own solicitor and for their views to be really expressed directly to their solicitor. Again, those are quite rare, and it really is the judge that will determine if that's necessary in all the circumstances of the case. But typically speaking, your child's involvement is really going to be just limited to a conversation with CAFCAS that's then reported back to the court.
That's all been really, really helpful. If there's one thing that you would like somebody listening to this who's either in court proceedings or about to issue court proceedings to really take away, what would that key takeaway be?
There is such an emphasis at the moment on non-court dispute resolution and trying to resolve disputes, whether they are financial or children disputes, away from the court process. And there are so many options available. So you can attend mediation, you can go to arbitration, you can have collaborative law. There are lots of options available for clients and lots of advice available to clients as well. So my advice really is to try and look at non-court dispute resolution if that's appropriate in your case. And also, even if you can't afford to have a solicitor represent you all the way through your matter, we do things like unbundling services, which means that we can provide advice on an ad hoc basis. And I think it's always really helpful to have that, because these are massive decisions that are being made about your family, about the centre of your universe. And it's helpful in almost all cases to have a lawyer, a legally trained person, provide some advice and guidance on what a judge is likely to do in this scenario. Because hopefully that, again, can help to narrow the parties' minds towards reaching a settlement and encourage that to happen if at all possible.
Brilliant. Well, thank you so much.
Thank you.